Let me just read just a little bit from Kennedy, where he talks about the 14th Amendment requiring states. This is from the decision. The 14th Amendment requires states to recognize same-sex marriages validly performed out of state. Since same-sex couples may now exercise the fundamental right to marry in all states, there is no lawful basis for a state to refuse to recognize lawful same-sex marriage performed in another state on the ground of its same-sex character. So, in other words, there you have it in terms of a marriage in one state recognized in another. But this is from the end of his opinion. Or I should say, here's another one. Here's another snippet. The nature of injustice is that we may not always see it in our own times. The generations that wrote and ratified the Bill of Rights and the 14th Amendment did not presume to know the extent of freedom in all its dimensions. And so they, remember, the 14th Amendment was written in 1868, I believe it was. It was definitely in the 1860s. I can't get dates so well this year, but 1860s. Let's call it 1865, 1868. 1868, of course. Of course it's the 1868 because it's after the war. The 14th Amendment did not presume to know the extent of freedom in all its dimensions. And so they entrusted to future generations a character protecting the rights of all persons to enjoy liberty as we learn its meaning. When new insight reveals discord between the Constitution's central protections and a received legal stricture, a claim to liberty must be addressed. Now, the idea that the Constitution is a living document is one that has been espoused by, openly, I should say, by left-of-center jurists for a long time. Stephen Breyer wrote a whole book on this. And the idea being that nothing or that much of what the future was going to hold could not be known by those who wrote the Constitution, right? I mean, they couldn't have known the size of the country 200 years later. They couldn't have known they couldn't have known what technology would bring. They could not have anticipated every new social dynamic. And so the idea is that the Constitution is constantly, but is reinterpreted through modernity and is updated as modernity arrives, I guess. And this is really not terribly controversial, because how could it be otherwise? How could it be otherwise? Now, I don't know that Kennedy explicitly accepts that notion of the Constitution, but he certainly expressed it there. I mean, he's attempting to express it in the sense that, well, we've changed. The Constitution has stayed the same. But no, the Constitution changes because, of course, we change. And anything that we interpret as human beings, if we have changed, changes. Because the literal Constitution has not changed. The words have stayed the same. It's still on a piece of parchment. But the meaning has changed. And because in 1868, when the 14th Amendment was written, and this is actually from Scalia's dissent, and I will get to that. Obviously, we had no gay marriage. We had no marriage equality. It's only recently, at that point, the 14th Amendment, like moments, that we didn't have slavery either. Let me go on with what Kennedy has written. No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than they once were. As some of the petitioners in this case demonstrate, marriage embodies a love that may endure even past death. The case itself was brought by a man whose, husband had passed away. That's not in the... their plea, I'm sorry, it would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution grants them that right. The judgment of the Court of Appeals for the Sixth Circuit is reversed. It is so ordered, and thus we have marriage equality in this country. Now, I'm not a terribly poetic person, and so I don't necessarily appreciate this. I mean, from my perspective, marriage, for all I care, can be an institution outside of government. But we do afford married people certain extra rights. I don't know, somebody counted them up, like 1,000 extra rights that are available to you if you are married. And in my estimation, the Constitution doesn't necessarily grant people equal dignity in the eyes of the law. The Constitution grants people the same rights to special privileges if it's awarded to one person as to another. And so if government's going to be in the business of sanctifying marriages, you got to do it for everybody. But nevertheless, people seem to appreciate the poetry. I mean, I hate to be the party pooper. But that's, and, you know, at the end of the day, it's simply about, we all know why gay people didn't have the right to marry as of, across the country as of 3 or 4 hours ago. It was just bigotry, period. And sadly, it took a long time for people to evolve beyond that bigotry to the point where there was a critical mass that forced the issue. And, you know, this didn't just happen naturally. It happened because there were incredibly dedicated and brave activists who, for 40 years, probably more actually, but have been fighting for this, have been fighting for these rights. So there's a huge lineage of people who have worked towards this moment. You know, that's incredibly moving.